Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss an important case law on injuries to the accused person. If in an incident the accused receives injuries, they have to be explained properly by the prosecution. Otherwise, the advantage will go to the accused person. This is what is stated in the case of Parshuram versus State of Madhya Pradesh. Parshuram versus State of Madhya Pradesh in Criminal Appeal number 524 by 2021, decided on 3rd November 2023 by 3 judges bench. Honorable Justice B.R. Gavai, Justice Madam B.V. Nagaratna, and 3rd Judge, his name I have forgotten, Prashant Kumar Mishra. They held that non-explanation of the injuries on the accused person will lead to allowing the appeal, and ultimately the case ended in acquittal. So the appeal was allowed in the Supreme Court of India. Now coming to the factual matrix of the case, this happened on 6th July 2021 in Madhya Pradesh. Actually, the appellant, he constructed a thatched hut just by the side of road, but it was causing obstruction. After construction of the shed, he has tethered his cattle. Pashul Katti said that. It was causing obstruction to the other cattle, to the other people like the deceased and others. Deceased name was mother. So there was a quarrel between the accused, present Parshuram and others, and the deceased on the other side regarding the tethering of the buffalo in the shed, which is an encroachment to the road. On 5th July 2021, an altercation took place between both of them. On 6th morning, the deceased and others, they were going on a tractor to the police station to complain about the incident, because on the last day they were beaten. So the accused, that is present appellant, or others, thinking that those people will lodge a complaint and they will be lugged in, they attacked them en route with deadly weapons, chased them, ultimately as a result of which they scattered, but one of them received injuries and subsequently he died. The injuries are not dangerous, not such severe injuries, but anyway he died. Since he died, the case under section 147, 149, 302, 326, 324, 307, all these sections have been put against the accused persons, and they were sent to the jail. The first ADJ Shivapuri, he has taken into consideration of the evidence of the witnesses, and he has given life sentence to two accused. Now the matter came to the Supreme Court, because the High Court also dismissed their appeals. Right? So case is okay, fine. The case was built up in a good way. But they clearly stated that they received injuries. Please remember, Parshuram and others, the accused persons, they received the injuries in the yesterday's, one day before yesterday's incident. They were not mentioned in the FIR. They were not reported during the investigation by the police. These people were not sent for medical examination, but they got medical treatment in a private hospital, and they produced the certificates. This was not taken into consideration by the lower courts, even as well as the Honorable High Court of Madhya Pradesh also. Please remember. And second, whether common object 149 is there or not. No doubt, if the meeting of minds, or if the object is there, even though they do not participate, okay, it can be allowed. But please remember, the defense taken by the accused is more important in this case. The defense taken by the accused is that when they were coming, when they were wanted to go to the police station, these people, the accused, not only actually in the beginning, just a few minutes back, I told you that the accused persons attacked them, but their place that the deceased group attacked them because they wanted to go to the police station. So that means it is a free fight. Each party is complaining against the other. That means it's a free fight. So they also received injuries. In the said free fight, the persons from both sides received injuries. As a result, in the free fight, the so-called Madan died. The injuries are not so serious. Right? The entire incident arose on the happening of next day, prior day, 1 day prior to the occurrence. So please remember, it is quite possible that the accused persons or the appellants did not have any intention to cause the death of the deceased, but only they wanted to teach a lesson to the appellants. Please remember, on account of the buffalo trespassing or the buffalo tethering to the so and so. So ultimately, the conviction given under section 305 IPC is altered to section 304 part 2. Already they are suffered 7 years of imprisonment. That is sufficient. Now they can come out from the gallows. So very good judgment. Important point is the IO has to explain the injuries to the accused also. Otherwise, things will be like this. So please read the case law and enrich your legal knowledge. Thank you.